Chapter 36. Suit to prevent or remove cloud on title. Statutory suit to quiet title. Analysis. Section 724. Definition of cloud on title. The authorities refer to the indefiniteness of the term cloud. In general, a cloud upon one's title is something which constitutes an apparent encumbrance upon it, or an apparent defect in it. It is something which is apparently valid but which is in fact invalid. Such clouds upon title as may be removed by courts of equity are instruments or other proceedings in writing, which may appear upon the records and thereby cast doubt upon the validity of the record title. A mere verbal claim or oral assertion of ownership in property is not a cloud which equity will remove. Section 725. Distinction between bill to quiet title and bill to remove cloud. Suits in chancery to quiet title, in the nature of bills of peace, have been defined in the last chapter. The distinction between these and suits to remove a cloud is not always observed. The equitable relief to remove a cloud from title is granted on the principle quia timit, that is, that the deed or other instrument or proceeding constituting the cloud may be used to injuriously or vexatiously embarrass or affect a plaintiff's title. Section 726. Prevention of threatened cloud. As a court of chancery may undoubtedly entertain a suit to remove an existing cloud upon title, so also it may, in a proper case, interpose its authority to prevent, by injunction, a threatened act from which such a cloud must necessarily arise. In such cases, however, the danger must be imminent and not merely speculative or potential. Section 727. Instrument constituting cloud. It is impossible to lay down rules which will cover all the cases in which a court of equity will interpose its jurisdiction to remove a cloud upon the title to real estate. This jurisdiction does not rest upon any arbitrary rules, but depends upon the facts of each case. Instruments and proceedings of every conceivable nature have been removed as clouds on title. A few of the cases are given in the note. Section 728. Adequacy of remedy at law. Underscore whether or not the jurisdiction will be exercised depends upon the fact that the estate or interest to be protected is equitable in its nature, or that the remedies at law are inadequate where the estate or interest is legal, a party being left to his legal remedy where his estate or interest is legal in its nature, and full and complete justice can thereby be done. Section 729. Does the jurisdiction extend to personal property? It has been held that a cloud upon the title to personal property, even by matter appearing of record, cannot be removed, but there seems no good reason for thus restricting the jurisdiction, and the instances are not infrequent where it has been exercised, in cases of void recorded chattel mortgages, spurious issues of shares of stock, etc. Section 730. Plaintiff's title. A bill to remove a cloud from title cannot be brought by a stranger to the title. Since the plaintiff must recover solely on the strength of his own title and not on the weakness of that of his adversary, it follows that he must have some title. It is not necessary that the claimant should have a prima facie record title, which the real owner must call in extrinsic evidence to overthrow, but it is sufficient prima facie if the complainant makes out a title apparently good. As to whether this title must be legal or may be equitable, the cases are not uniform. The better opinion appears to be that the proposition that only the owner of the legal title can remove a cloud is not only not sustainable upon authority but is not supported by the reason which lies at the basis of such actions. That reason is that the party has no adequate remedy at law, and that to require him to await the action of the party claiming under the instrument or other matter constituting the cloud, until perhaps his evidence and ability to defend against it is lost by lapse of time, would, in many cases, be to deny him any remedy. The reason is as forcible in the case of one holding an equitable estate or merely a lien, as in that of the legal owner. A party who has been in adverse possession for a period of time, which, under the statute of limitations, vests him with a title against all the world, can bring his suit against a party claiming under a record title, to have the claim determined and adjudged null and void as against him. The statute of limitations as against a party claiming under a written title would have performed but half its mission, as a statute of repose, if the party relying upon it must wait till he is attacked before he can reduce the evidence of his title to the form of a permanent record. Section 731. Possession of plaintiff. as to whether possession by a plaintiff is necessary before he can resort to equity to remove a cloud, there appears to be some conflict of opinion, arising from loose and careless statements of judges, and an overlooking of the principles of equity in regard to the exercise of its jurisdiction. When the estate or interest to be protected is equitable, the jurisdiction should be exercised whether the plaintiff is in or out of possession, for under these circumstances legal remedies are not possible. But when the estate or interest is legal in its nature, the exercise of the jurisdiction depends upon the adequacy of legal remedies. Thus, for example, a plaintiff out of possession, holding the legal title, will be left to his remedy by ejectment, under ordinary circumstances. But where he is in possession, and thus unable to obtain any adequate legal relief, he may resort to equity. Where, on the other hand, a party out of possession has an equitable title, or where he holds the legal title under circumstances that the law cannot furnish him full and complete relief, his resort to equity to have a cloud removed ought not to be questioned. While it cannot be said that the cases are uniform on the above propositions, still it is believed that the rule stated in section 728, and the above explanations are founded on principle and are sufficient to reconcile a vast majority of the conflicting, or apparently conflicting, judicial opinions and dicta on this question. In some of the cases the rule is so broadly stated as to require a plaintiff, seeking to have a cloud removed, under all circumstances to be in possession. On the other hand, it is as generally stated that possession is never essential. Both of these extreme views are open to criticism, and the cases should always be considered with reference to the facts actually before the court. Where, however, neither party is in possession or where the lands are wild and unoccupied, it has been generally admitted that the remedy at law is inadequate and that equity has jurisdiction to remove or prevent a cloud. Section 732. Sufficiency of possession. Actual possession with a claim of ownership in fee establishes a presumptive title and is sufficient to maintain a bill to remove a cloud upon title. The possession must be bona fide and fairly gained. It must have been acquired in a lawful way. If it has been obtained by violence or by the use of any unfair or corrupt means or by fraud, equity will not lend its aid. Aside from the general rule as above stated, what is a sufficient possession to sustain the jurisdiction of equity depends on the particular facts of each case. Section 733. Instrument invalid on its face, no relief. While a court of equity will set aside a deed, agreement, or proceeding affecting real estate, where extrinsic evidence is necessary to show its invalidity, because such instrument or proceeding may be used for annoying and injurious purposes at a time when the evidence to contest or resist it may not be as effectual as if used at once. Still, if the defect appears upon its face, and a resort to extrinsic evidence, on the part of the complainant, is unnecessary, the reason for equitable interference does not exist, for it cannot be said that any cloud whatever is cast upon the title, as a part of the same doctrine. The further rule is generally established, that where the instrument or proceeding is not thus void upon its face, but the party claiming under it, in order to enforce it, must necessarily offer evidence which will inevitably show its invalidity and destroy its efficacy, in each of these cases the court will not exercise its jurisdiction either to restrain or remove a cloud, for the assumed reason that there is no cloud. Section 734. Same. Limitations on and denial of this doctrine. The second rule, as stated in the last section, is subject to a number of limitations, some of which have given rise to a sharp conflict of authority. In many states, deeds, certificates, and other instruments given on sales for taxes are made prima facie evidence by statute of the regularity of proceedings connected with the assessments and sales, and it is well settled that courts of equity will set aside such instruments for defects, though such defects are apparent on the face of the proceedings leading up to the execution of the instrument, or, in a proper case, the execution of such an instrument, prima facie valid on its face, will be enjoined. It is also a rule in many jurisdictions that where the title of both complainant and defendant are derived from a common source, but defendant's title appears by the records to have originated subsequently to the complainant's title, so that by an inspection of the whole record it appears that the defendant's title is prima facie inferior to that of the complainant, the complainant is still entitled to equitable relief, since he would be required, in an action by the defendant, to offer evidence of his own prior title in order to defeat a recovery. In New York, however, and a few other jurisdictions, the contrary is the rule. If it appears by the whole record that the complainant's title is paramount, there is no cloud to be removed. In pursuance of the general doctrine, it is usually held that if the defendant's title is derived from a complete stranger to the complainant's title, from one who never had any connection with the property, it does not constitute a cloud, as, where an execution is levied upon lands owned by complainant, issued upon a judgment, in an action to which he was not a party, against one who never had any interest in the lands. But in several states such levy may be enjoined, on the general theory obtaining in such states that a void act under color of judicial process is subject to injunction. Finally, the doctrine itself has been condemned as wholly impractical and unreasonable, and in a few states, has been rejected. While this doctrine may be settled by the weight of authority, I must express the opinion that it often operates to produce a denial of justice. It leads to the strange scene, almost daily in the courts, of defendants urging that the instruments under which they claim are void, and therefore that they ought to be permitted to stand unmolested, and of judges deciding that the court cannot interfere, because the deed or other instrument is void, while from a business point of view every intelligent person knows that the instrument is a serious injury to the plaintiff's title, greatly depreciating its market value, and the judge himself who repeats the rule would neither buy the property while thus affected nor loan a dollar upon its security. This doctrine is, in truth, based upon mere verbal logic, rather than upon considerations of justice and expediency. Section 735. Statutory suit to quiet title, in general. The equity jurisdiction to quiet title, independent of statute, was intended to protect the legal owner of the title from being harassed by suits in regard to that title. It was invoked only by a plaintiff in possession, holding the legal title, when successive actions at law, all of which had failed, were brought against him by a single person out of possession, or when many persons asserted equitable titles against a plaintiff in possession holding the legal or inequitable title. The action has been greatly extended by statute, and in many states is the ordinary mode of trying disputed titles. Very frequently, proceedings under such statutes are not designated as proceedings to quiet title but are known as proceedings for the determination of adverse claims. The statutory action to determine an adverse claim is an improvement upon the old Bill of Peace. The statute enlarges the class of cases in which equitable relief could formally be sought in the quieting of title. It is not necessary, as formerly, that the plaintiff should first establish his right by an action at law. He can immediately, upon knowledge of such claim, require the nature and character of the adverse estate or interest to be produced, exposed and judicially determined, and the question of title be thus forever quieted. Section 736. Remedy, whether equitable or legal. It has been held, in every state but one, and in the United States courts, that the remedy created by these statutes is an equitable remedy, in the instances where the defendant is not in possession of the land, and that neither party is of right entitled to a jury trial. Where, however, the defendant is in possession, it is held, in most jurisdictions, that he is entitled to a jury trial, at least when the complainant seeks restitution of possession as part of his relief. Section 737. Possession of plaintiff. The states adopting such statutes may be separated into two classes, the first and most numerous class requiring the plaintiff to be in possession, and the second allowing the action to be brought by a plaintiff either in or out of possession. Under both classes of statutes the right of an owner in possession of lands to maintain a bill to quiet title is undoubted, for he has no adequate remedy at law. In regard to the nature of the possession requisite to maintain the action, there is some conflict. It has been held on the one side that possession must be lawful, must be accompanied by a claim of right, legal or equitable. Such cases hold that equity will not assume jurisdiction where the possession was acquired by trespass or by unfair means merely for the purpose of filing the bill. On the other hand, it is held that it is immaterial how possession was acquired, by fraud, collusion or otherwise, so long as it exists. In those states in which possession is required, The possession must be actual as distinguished from a constructive possession presumptively arising from the legal title. In other words, it must be a possession in fact as distinguished from a mere legal or civil possession. Some of the statutes expressly provide that the possession of the tenant shall be equivalent to actual possession by the landlord. In the states where there is no such express provision, the courts nevertheless have held that actual possession by the tenant is sufficient to support the landlord's suit. Section 738. Title of plaintiff. As a general rule, the suit may be brought by anyone claiming some right or interest in the land. In most of the states, the owner of an equitable interest as well as the holder of the legal title may maintain the suit to determine adverse claims. Section 739. Nature of the adverse claim. In general, it may be said that the action may be brought against any person claiming an adverse interest, of whatever kind. The words claim an estate or interest, which are the usual words of the statutes, are used in a broad sense and are not technical in their meaning. Though the defendant's claim is worthless, and void upon its face, yet if it be hostile to the plaintiff and cloud his title so as to depreciate the market value in the estimation of businessmen, the action can be maintained. It is also immaterial whether or not the defendant claims under the same or a different and independent source of title from the plaintiffs. Neither is it material whether or not the defendant has actually asserted such claim before the commencement of the action, as it is one of the essential features of this action, wherein it differs from the original equitable suit to quiet title, that the plaintiff need not wait until proceedings are brought against him. There is some diversity of opinion as to whether the action will lie against a mere lien claimant. Under those statutes permitting the action to be brought against anyone asserting a claim, it seems that the action lies against the assertion of a lien, but where the statute permits the action only against one claiming title or an estate, it cannot be brought against one who asserts a mere lien. Section 740. Service of process by publication. The action is a clear instance of those suits quasi in rem, in which substituted service or service by publication may be authorized on defendants not found within the jurisdiction, and such service is expressly authorized in this action by the statutes of many of the states. Section 741. Pleading. On the part of plaintiff. In accordance with the general rule relating to statutory proceedings, it is sufficient if the bill or complaint embodies the essential averments of the statute. It is sufficient to allege the title or interest of the plaintiff in the land, and that he has the possession thereof, where the statute requires the plaintiff to be in possession. Under those statutes where possession in the plaintiff is sufficient, ownership in the plaintiff need not be alleged. It is not generally necessary to allege the nature or extent of the defendant's claim, nor is it necessary to point out the defects therein. It is sufficient to aver that the defendant claims an estate or interest in the property hostile to that of plaintiff and that he has none. Section 742. Defendant's pleadings. If the defendant does not claim any adverse estate or interest, he should file his disclaimer. Where the defendant does not disclaim but puts in an answer, he must set up therein whatever right, title or interest he may claim in the property. As the basis of the right to require the adverse interest to be adjudicated is the plaintiff's own interest or ownership in the land, where such interest or ownership is controverted by a general denial, a sufficient issue of fact is raised. Section 743. Judgment or decree. While a decree quieting title is not, strictly speaking, in rem, it fixes and settles the title to real estate, and to that extent it partakes of the nature of a judgment in rem. The court may settle finally and adjudge whether the defendant has any right, interest or estate in the lands, and declare what such interest, estate or right may be, or the defendant's claims may be decreed to be invalid, or it may grant an injunction, as ancillary to the principal relief, restraining the assertion of such claims, or in those states where the statute, by its express terms or by its general language, permits the action to be brought to remove a cloud, deeds and instruments may be ordered to be cancelled. When the plaintiff is out of possession, and the action is authorized to be brought by one out of possession, a writ of possession may be granted in the decree, whenever the justice of the case demands it.